If you would like to participate in some activist skullduggery and you're between the ages of 18 and 20 years old, then you might consider it time to sue your FFL. And this is the type of lawsuit that we're talking about where both the plaintiff and the defendant want the plaintiff to prevail. And of course, what we're talking about in this instance is the Fraser case, or the Fraser versus ATF case out of the Eastern District of Virginia. And this case is fantastic. We have covered it previously here on the channel, and Jared put out a full expose just a couple days ago about what went down, but I was out for the weekend, so I'm playing catch up. And to fully catch up, to kind of lay the groundwork on what it is that I alluded to in the intro of the video, this case is a direct constitutional challenge to the concept that has been created by a suite of laws and regulations that generates a prohibition on handgun purchase for individuals under the age of 21. These gentlemen challenged this suite of laws that have created, again, this idea that 21-year-olds cannot purchase handguns legally from a licensed federal firearms dealer. And in taking it to court, the district judge said, oh yeah, that is 100% unconstitutional. There is nothing in the text, history, or tradition of the United States that even closely approximates an analog to this sort of thing. That thing is out of here. And from that, what he did is he basically sent the government and the plaintiffs to mediation, said, hey, y'all go figure out how you guys want to make this copacetic and bring it into balance, and you come back and report to me. Well, they issued that report, and what it turns out, it seems, is that, they couldn't agree. Shocker, right? Because the plaintiff said, yeah, all 21-year-olds, handguns now. And the government was like,
no, it should only apply to these guys over here that actually sued us. Please keep the scary attorneys away from us.
Well, I'm going to read to you exactly what the judge said because I couldn't put it any better myself. But before we do that, I need to spend a couple seconds to pay the bills. I'll be right back in just a few. Kentucky Gun Works is best known for their research and development into lubrication technology. They use their enhanced reliability oil on a daily basis, but they've started to move into some other stuff, like, for instance, they recently came out with their slings, equipped with a fast adjust that allows you to get out of it really quickly. And they've also recently released their minimalist quick-released sling retainers. KGW offers VSO subscribers a discount, and you can find that information over at the affiliates page. Special thanks to them for making today's video possible. Now, as I alluded to before the sponsor sought, this is an excellently written document. It is 25 pages, and it is a fantastic read if you just want to nerd all over the place. I'm going to pick up with you on page 23, where we get to the meat and potatoes of the conclusion by this judge. In this case, the harm, the violation of the plaintiff's Second Amendment rights, extends to all members of the class, and that class is a certified class of people between the ages of 18 and 20 years old. So 1 day minus their 21st birthday. That is the class as defined. So the remedy must too. The court found the challenged law and regulations facially unconstitutional, thereby carrying out its duty to declare all acts contrary to the manifest tenure of the Constitution void. Then cites Federalist 78. This voided the legal regime may therefore not be enforced at all. In other words, the court's ruling does and must apply to protect the Second Amendment rights of all citizens between the ages of 18 and 21 who are otherwise eligible to buy a handgun. In no way was either the substantive decision or the class certification decision in this case limited or influenced by the fact that the named plaintiffs live in the Eastern District of Virginia, Commonwealth of Virginia, or the Fourth Circuit. Indeed, aside from the procedural question of venue, this case's substantive outcome on the merits would be the same if the individuals resided on the opposite side of the country. In sum, people between the ages of 18 and 21 in the Eastern District of Virginia suffer equal burden as people of the same age in the Southern District of New York, the Central District of California, or any other district. The government's policies affect and harm each of them equally. Therefore, the categorical policies relied upon by the government call for categorical relief. Only a nationwide injunction will prevent irreparable harm to the plaintiffs who, since as class has been certified, include all American citizens between the ages of 18 and 21 who are otherwise qualified to purchase a gun. And then the only caveat that the judge says that this does not apply to are the following districts: the Western District of Louisiana and the Northern District of West Virginia, because they have currently parallel legislation occurring, which means that there are cases dealing with this exact issue in their courts. So the judge is basically saying, I am going to respect the sovereignty of the courts that are currently deciding for their citizens, is all that he said there. For the reasons set forth above, plaintiff's motion for declaratory judgment and injunction will be granted, and defendant's motion for entry of judgment in separate order will be denied. So currently, there is, in effect, a nationwide injunction against this suite of regulations saying that if you are under the age of 21, so if you're 18, if you're a legal adult that's able to vote, you have to sign up for the selective services, you can be drafted and pressed into service into any military conflict in the world by your government and potentially die for your flag, then yeah, you can buy a handgun. That's what this decision says, and it is a blanket nationwide injunction except for those two places that were previously mentioned because, you know, the sovereignty of their decision-making process is being respected. Got it. However, as a federal firearms licensee, I have received no notification whatsoever from the ATF that this is a thing. This happened last week. When major policy changes like this occur, you would expect the regulatory body that handles stuff like this to send out some kind of blanket communication. We've seen it for much smaller things than changing a decades-old rule on whether you can sell to a particular class of people or not. They would usually send even some kind of automated message for that sort of thing. We have not received anything. And along those same lines, I go to the ATF's website and I can find no mention of this whatsoever. Now, I have not contacted my IOI to ask about this. I didn't want to bring any of them into it. I just simply wanted to say that in a vacuum, if you were not an FFL that was super plugged into this process, like, say, me or anybody who watches this channel, then you would have no idea that this is a thing. And if some 20-year-old individual were to walk into said business and try to purchase a firearm, they would likely be told that if they tried to purchase a handgun by the owner of the establishment or whoever is working there, that's a no-go, bro. I can't do that because I guarantee you they are currently pulling people's licenses for spelling words wrong. Clerical errors. What do you think they're going to do to you if you just suddenly violate a federal law? So currently, as I said, there is no mention of this happening whatsoever, except for those of us who are tracking the court cases. No word has come down on this. So it is my proposal that if you are an FFL and you have clients that are under the age of 21 and wish to purchase a handgun, that y'all get together and have a talk with some attorneys, and perhaps that young individual should consider suing your establishment for $1, in which case you will ineptly defend your position to not sell to that individual because of this federal regulation. You are basically, as an FFL, have your hands tied currently on what you can and cannot do. The situation is ripe for a whole bunch of businesses to be compelled by judges to sell legally tenured firearms to young individuals. And that would be absolutely fantastic. I want to know what you guys have to say about this situation in the comment section down below, because this whole thing about infringing on the rights of a class of people that I would by all logical estimations, say is an underprivileged class. Because if you think about 18 to 20-year-olds, they don't got a whole lot of money. They don't have a whole lot of experience. They don't have a whole lot of resources unless, there's a small percentage of them maybe. But I don't know about you, but when I was 18, 20 years old, I was broke as a joke. I work in guns. I'm still broke. But these kind of regulations have stood so long. One, because we have not had the legal framework to challenge them until the Bruin decision came up. And two, this class of individuals has very little recourse because oftentimes these cases take so long that they just age out and the whole situation becomes moot, or they just simply don't have the resources to litigate it and they're screwed. So they're handed a no-win situation where they just basically sit down and take it because they literally have no recourse. Well, here we have a situation where justice has been done, and I would like to see it get pushed and pushed and pushed because I guarantee you that this ruling is going to be appealed. And of course, we'll be covering that here at the VSO Gun Channel. Thank you for tuning in, and hopefully we'll see you in another one here in pretty short order.